The judge's surprising ruling leaves investors wondering if they can really be held liable for market losses. Trading positions concentration sparks probe into fraud allegations, but does it mean every regulatory breach is a fraudulent activity? Regulatory breaches are not necessarily fraudulent activities. SEBI cannot decide fraud with unfettered powers. Both intention and act must be considered for deciding fraud. We cannot make both intention and act irrelevant factors for deciding fraud. Supreme Court. The Supreme Court has delivered a crucial judgment on the interpretation of the SEBI Prohibition of Fraudulent and Unfair Trade Practices, Regulations, 2003. The bench, comprising Justices J.B. Pardiwala and R. Mahadevan, held that a breach of regulatory requirements under the securities law framework cannot, by itself, be elevated into a finding of fraud. The court emphasized that both mens rea, intention, and actus reus, unlawful action, cannot be made irrelevant factors for deciding fraud. The ruling clarifies that SEBI cannot exercise unfettered powers while determining fraud and instead must consider the distinct and higher threshold required to establish fraudulent conduct. The court cautioned against an excessively literal interpretation of Regulation 2(1)(c), which defines fraud, as it could render the definition so broad that it covers virtually every market act or omission. Was this verdict fair or did the judge go too far? Tell us in the comments yes or no.
Here's what this means for you. If you suspect market manipulation, report it to SEBI within 30 days and request an investigation. Save this video for future reference.
Follow Legal Output on Instagram and Legal Output Official on YouTube for daily legal updates.